Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled to have someone who's been way too long since I had him on the pod, and that's my U of M compadre, James Koukios. James, welcome back to the podcast.
I haven't had a chance to say this to you in a while, Tom, but go blue.
Go blue. Unfortunately, we're not going to simply talk about U of M football, but we're going to talk about a great article James had posted this past week, I think, on Law 360. It is entitled, Expect DOJ to Repeat 4 Themes from 2024 FCPA Trial. So it gave me an excuse to contact him, and he graciously agreed to come back on the pod. So first of all, welcome back, and tell us what led to the article.
Well, thanks for having me, Tom. Always a pleasure. And I agree, it's been too long. I tried 2 FCPA cases back in the day when I was at DOJ. And so we thought a lot about how best to position those trials at the time. And I just thought it would be kind of useful to take my own experiences, kind of look at with all the trials coming up this year and next year, and the fact that there was a lot of trials last year, kind of use my experience to read some of the openings and the closings from those trials and try to get at what are the themes that DOJ is going to try to use to really move the juries into convicting FCPA cases, both because I think it's just interesting. I really appreciate the craft, the thought that goes into these on the parts of the prosecutors, but also as a defense attorney, how are you going to be able to use those expectations, those themes to maybe come up with some effective defenses? So we took a look at the trials from last year and put together this article about the themes.
And I certainly wanted to talk to you about that. I looked at it with an eye perhaps from a compliance practitioner's perspective, and what that a compliance professional could suss out that were DOJ expectations, or at least priorities for this administration, and then use those priorities, if appropriate, to either pressure test or do a gap analysis of your program, or actually incorporate some of these ideas into the program. Maybe if we could start with a quick recap of the 2024 trials, because I've always said if you told someone the underlying facts of an FCPA trial, they would look at you and said, you made that up. Nobody would do that. And Vital, the Jose Aguilar, was as great an example as I've seen. But so why don't you tell us about the 2024 trials?
So you raise a good point before I do that one of the benefits of reading these openings and closings is you do get the sort of the details. This is how it actually goes down in real life. And people actually do use these consultants, these fake consultants, and they really do use these shell companies and things of that nature to do this. So I think you're exactly right there. There were 3 trials, I should say, in 2024 in FCPA or FCPA related matters. The first one was in February of last year. A gentleman named Javier Aguilar, who was associated with the company Vital Inc. He was tried in Brooklyn for conspiring to violate the FCPA and to commit money laundering, and also for violating the FCPA in connection with alleged bribery schemes in Ecuador and Mexico. The next one was April 2024. This one was tried in my old stomping grounds of Miami, the Southern District of Florida. And that one was actually the FCPA related trial, because that was actually the trial of an Ecuadorian official who had allegedly received bribes from Brazilian and Ecuadorian business interests and laundered much of the proceeds through Miami and other places in the Southern District of Florida. And then finally, a little later in the year, September of 2024, Glenn Ostamel, and this case was tried in Connecticut, was accused of conspiring to violate and violating the FCPA and money laundering statutes related to a bribery scheme in Brazil. And one thing I think is worth pointing out, Tom, even though all three cases were along I-95, we went all the way from Miami to Brooklyn to Connecticut. So you had 3 very different jury pools, and still DOJ was able to use some of the same themes in all 3 cases very effectively to motivate all 3 of those juries. Tom, I can't hear you. Sorry.
It always helps to keep your mic on. But what were some of the key themes you saw prosecutors lean on for each of these cases, or break it down in the way you did for the article?
Sure. The first theme was one that was really kind of close to my heart, because I tried 2 FCPA cases down in Miami back when I was a prosecutor. And I remember that when we were getting ready for trial, one of the biggest concerns that my boss at the time had, Chuck DeRoss, who's now my partner at Morrison Forster, was why are people in Miami going to care about bribery that happened in Haiti? And we really need to make them care about this, because for a lot of people, and you heard this sometimes, people would say, why do I, somebody in the United States, care about how governments do business in somewhere else? And one of the things we did back then, and I saw echoed in these trials, was really to try to get the jury to understand that these things impacted them, even if they didn't live in the place where the government was being corrupted. The one that I thought was probably that happened the most in was the maybe not coincidentally, was the case in Miami where the Ecuadorian official was tried. And there, during both opening and closing, prosecutors said almost about 24 times that certain of the conduct happened, quote, here in Miami, unquote. And they would point out, for example, real estate that the defendant bought just down the street from the courthouse, that there were certain bank accounts that were in Miami. And I thought that was really effective, and that's what we did in the Duperval and Eskenazi trials. We mentioned that Eskenazi was a businessman in South Florida, but for Duperval, the official, he created fake companies in Miami. He bought things in Miami. He had bank accounts in Miami, and I thought they did a very similar thing very effectively in that Polite trial, which is to say that real estate was here, those bank accounts were here. This affected you. And I think one thing, too, the kind of reading between the lines, a lot of the property that the defendant was buying in Miami was in pretty desirable neighborhoods, and it was kind of luxury real estate or in like really nice areas. And I think especially if you're not meaning to be pejorative, but if you're a working stiff who has to take off from work and you sit there and you're listening, I have to sit here and maybe not get paid for my job while this guy is just exploiting his position to drive real estate prices up for me. I think that can be really effective. And they did that in the other trials as well, a little bit less so because the ties were not quite as strong in Brooklyn and Connecticut in terms of some of the conduct. But they still did find the opportunities to say, look, stuff was going on in your neighborhood. And that's one, they didn't come out and say it, but that's kind of implicitly why this should matter to you. And I thought they did that very effectively.
James, I certainly understand personalizing your case to the jury or the facts and circumstances, but this took it a level far further, I thought, because it brought it local, and it really brought it even into the local economy. And for a compliance takeaway, I wanted to pitch this to you and see if you thought it was valid. The compliance officers need to make employees understand that, exactly as you said, something may have happened overseas, but the economic fallout can be equally bad, and certainly reputational damage in your own community if you allow this to happen.
No, I think that's exactly right. And when we first started doing FCPA cases, we also had to convince judges about that too, because they were kind of like, why are we trying a case about corruption in Ecuador in my courtroom in Miami when there's drugs being sold and violent crime happening and healthcare fraud happening? And I think this also helps just across the board. This does impact us. This does happen. So I think it's a really important point. I want to make one aside, Tom, if you don't mind.
Sure.
All three of those cases had a touch point in Miami. And I used to say that for about 90% of FCPA cases, you could actually bring them in the Southern District of Florida, because there's either a meeting that happens in Miami, or somebody went on a flight through Miami, or the money was laundered in Miami. So I don't know, this is a tongue-in-cheek, but maybe one compliance takeaway could be if there's a lot of meetings going on and things happening in Miami, you should look into it. That's coming from a former Miami prosecutor.
Well, actually, that's a really interesting point, and let me see if I can maybe look at it from a different angle. And the first couple of times I went to Miami, that struck me as well, because I had sort of seen Texas as the gateway into Latin America, certainly in Mexico and Central America. And it may be a gateway, but Miami is equally a gateway. And if you look at a map, Miami is directly north of Venezuela almost. So you begin to see the connections, and maybe not as much energy in Miami, but they certainly had a large energy presence. But all other forms of business were run out of Miami. In terms of risk for a compliance officer, if you're in Miami, you're probably doing business in Latin America, and you're maybe doing business with governmental entities or state-owned enterprises. So I think that observation is spot on.
Yeah, and the thing I think to add about Miami that's a little bit even more so than Texas is people like to come to Miami to spend money. It's a entertainment capital, it's a food capital, it's a luxury good capital. And so a lot of people just come to Miami to spend their money. And especially if that money is illicit and you didn't really earn it and you want to go spend it and have fun, it's an attraction. It's like that anywhere. I mean, it's not just Miami. And please, for your Miami listeners, like, don't get mad at me. I lived down there as a prosecutor down there. I saw it, but I think it's a place where people are flashy, where there's like a lot to do. So people meet there, they spend money there.
And I would just now add, as a risk factor or a compliance takeaway, where are you doing business? And not in Venezuela, but where in the U.S. are you doing business? It may be a gateway to a high-risk jurisdiction.
That's right. Exactly.
Okay, abuse of power or violation of the public trust. How are the prosecutors able to make that seem important for something that may have happened outside the United States?
Yeah, so this theme and the next theme are really kind of the flip side of each other. They kind of go together. And this one is abuse of power. The next one is to be financial motive. But every corruption case at its core is about abuse of power. And obviously, as part of the elements of an FCPA case, you have to, as a prosecutor, prove that somebody paid money to a government official to get that government official to misuse his or her authority in the person's favor. So it's an element of the crime. But it also, if you think about it, to me, if you really can hit that point, not just as an element, but as a theme, it can be really effective to the jury, because I think, generally speaking, jurors in the United States expect good government. They expect our government to work on our behalf, and whether it's our government or another government, and they don't like it when officials abuse their power. And that's definitely one thing that the trials in 2023 emphasized, that this was not just kind of a technical violation. It was somebody who actually was in a position where they were supposed to do something for the people of their country, and they abused that power for their own purposes. For example, again, going back to the Miami trial with the Ecuadorian official, the government stressed that it was the defendant's duty to, quote, make sure that Ecuador's government's money was used properly. But instead of just doing his job, he monetized that authority and he lifted fines, he manipulated audits, the things that he was supposed to be doing to safeguard the fisc of the country for his own benefit. In the Aguilar case, prosecutors told jurors that the officials Aguilar bribed, quote, held positions of influence in public trust, and that Aguilar then induced those officials to sell that trust for contracts. And again, in the Ostmel case, they emphasized that the officials involved had a fiduciary duty to Brazil that those officials violated. And so I think, again, it's not just about fulfilling the element, but kind of tapping into the jurors' sense of fair play and what governments should be doing for their people.
And here's my compliance takeaway from that, James. It's that abuse of power is not just a courtroom theme. It's also in the corporate world as well. And that compliance professionals need to not only train and communicate to leaders and managers, but put processes and, more importantly, internal controls to prevent the misuse of things like conflicts of interest, undue influence, or even improper discretionary decisions, and remind employees that the perception or the even offer of something illegal, like a bribe, can get you in a lot of hot water.
Absolutely.
So how about the financial motive or the greed, if we want to go all Gordon Gekko here?
Greed is always one of the favorite themes of any white-collar case for a prosecutor. It's something a lot of judges always say, motive is not an element. It's true that motive is not an element, but it is a way to prove intent. And if you're able to say people did these things because they were greedy, you can help convince the jury that they intended to do it. And of course, in any financial crime case, this is going to be great. When it comes to the official who is on trial, as I said, the financial motive is kind of the flip side of the abuse of power. Why did he abuse his power? Because he was greedy and wanted money to himself. And of course, that trial, we've already talked about it. They talked about all the money he made, how he was able to buy luxury real estate in South Florida. Pretty easy. I think the harder one for a jury is, in some ways, if you own your own business and you're paying bribes, the financial motive is clear. If I sell more widgets and I own the widget factory, I'm going to make more money for myself. We certainly had that in Eskenazi, for example. Joel Eskenazi was the owner of the telecommunications company that was benefiting from the bribes to a Haitian official. So that was kind of easy. In the other cases this year, they were a little harder because the defendants, Aguilar, for example, worked for a big company called Vital. And I think a lot of people think to themselves, well, why would you risk your liberty to make money for a company? That doesn't make any sense. Or at least, it just doesn't feel like it's worth the risk. And so I think in that case in particular, the prosecutors had a really great rebuttal to that and a really good way to get out of there. They pointed out how much Aguilar actually made personally. Even though it was Vital who got the contracts, they were able to point out how much Aguilar personally made from this. And they noted one thing is that he got a salary. So look, if he successfully keeps his job, but he also gets a bonus, right? It's not just about getting a salary, but if he's making a lot of deals, he gets a bonus as well. And probably most important for the rhetorical value in this case, Aguilar actually got equity in Vital. And so in many ways, when the company did better, his equity also grew. And so I think they had a really good line in there. First of all, they said, when Vital made money, he made money. And they said the value of his equity shares in Vital skyrocketed. And that was a great word. It's one of the colorful words, right? It's not just went up. That'd be boring. Or it rose. They really used this great word, skyrocketed. And it did. It went, as they said, it went from 6.2 million when the scheme began, quote, all the way up to $75.5 million. So it really did skyrocket. And I think that's another really good way to say, especially when it's a business crime where ostensibly maybe the business is benefiting. Like, no, the guy also who authorized the bribes, who paid the bribes, he also personally benefited. And I thought they did a very effective job in that. In other cases, that may not be so direct. And I think that's a good lesson for defense attorneys. Why would a workaday Joe just risk his freedom and stuff like that? But I think Aguilar had at least from the government's perspective, had a much more personal motive in it.
James, for the compliance professional, to me, the takeaway is clear, and it's something that the DOJ talked about a lot since 2020 in the various iterations of the evaluation of corporate compliance programs, and that's financial incentives. Yep. Obviously, you need financial incentives for salespeople, but you can align them with compliance and ethics, and you can't make them so one-sided on the sales side of things that they get out of whack. And that's clearly what happened here. So take a look at your financial incentive package. And if you need to sort of recalibrate it, do that, document it, and be ready to answer any questions. So should a regulator come knocking?
Great point.
So you've got a great one that probably applies to parents, probably applies to compliance officers, corporations, and certainly prosecutors, and that's concealment.
Yeah, this is always the fun one. And I think probably most directly relevant to compliance officers, because this is the one you always want to read the FCPA enforcement actions and say, how did the guys get away with this? How did they get the money out of the company, stuff like that? And the sham consultants, the use of personal communication devices, all those kind of things are, I think, really important. But it's evidence of consciousness of guilt, right? You don't do these things, and that's the common sense appeal to the jury is you don't conceal your conduct if you don't think it's wrong. And why else did they do this? And I think there's some really good quotes in there and some really good anecdotes in there. In the case that involved the official laundering money, There's a great quote that they noted right away in the opening is that the defendant had asked somebody to help make his money, quote unquote, disappear, which is a great line, right? Through various financial and real estate transactions in South Florida. But then you go kind of the Aguilar case, and that I think important for the compliance officers. There were alias email accounts, there were sham consulting contracts, there were shell entities, there were layered transfers of money. And the prosecutors, I think, very effectively pointed to all these things during opening and closing and said, look, these aren't legitimate business practices. These are deliberate efforts to avoid detection. And that shows that they knew that these payments were bribes. And also, of course, they were charged with money laundering as well. It's an element of the money laundering as well. We're making these transactions to conceal what's going on. And then in the Ostamel case, the prosecutors were able to point, again, to fake consultant agreements, use of various intermediaries that didn't make a lot of sense, disguised bank transfers. And again, they were able to use that to show, look, these weren't legitimate transactions, and nobody who were involved in these types of transactions would think they were. And so they were very effective rhetorically and to prove the elements that the defendants knew what they were doing and had consciousness of guilt.
James, I guess for the compliance practitioner, I would reiterate what is, I think, the three most important concepts in any best practices compliance program, which are document. And I might add transparency, because if you're operating with transparency in a documented way, this hopefully you would detect, but more importantly, prevent. But clearly, if you're hiding it, you're doing it for a reason, and it's because you know something's wrong. And there we are with intent.
Yep. And look, it goes back to the third-party due diligence. It goes, again, underlines the importance of that always. And then the thing that DOJ has been hammering for the last 10 years or so, off-channel communications, right? It's, I think very much for all of us, it's the hobgoblin. It's what do you do with them? How do you try to prevent people from using the off-channel communications? There's no, obviously, as all your listeners know, there's no bulletproof way to do that, but it does reemphasize how it's important to try as much as possible to get those sensible policies in place and whatever else you can do to try to keep that from happening.
James, we've got three cases that you've identified that look like they're going to go to trial in 2026. How does what the DOJ did in 2024 lend or lead you to look at what it may do in 2026? And let me flip it over to, if one of the defense lawyers called you and said, James, we need a defense lawyer mentality here, what might you suggest some of the defenses they could at least put forward?
They should hire me, of course. I'd love to go to trial in one of these on the other side. Be a lot of fun. So yeah, just to set the stage, one of the trials already happened. It just concluded in Miami, the Zaglin case, which was involved bribes paid to a Honduran official. I haven't had a chance to look at the openings and closings in that, but from the press coverage that I read, very similar themes as before. I think we've actually got two trials coming up in October. One is the Bautista case, which is the Smartmatic case, as many people may remember from the 2020 election, but they're alleged to have paid bribes to get contracts for voting machines in the Philippines. That's supposed to happen in Miami in October. The one case that was just indicted in August down in Texas, my understanding is the defendants have asked for a speedy trial, and that is actually set for October as well. So that happened after I published the article, so I wasn't able to put that one in there. And then there's the Charles Hobson case, which is a coal executive out of Western Pennsylvania who allegedly paid bribes to Egyptian officials in order to get coal contracts. And I'll kind of talk about that one now, because if you read the indictment, it lends itself to all these themes. So in that case, DOJ alleges in the indictment that the defendant paid bribes to Egyptian officials so that they would abuse their positions of power, that the defendant not only arranged for bribe money to go to the officials, but kept part of the money for himself. So it really shows kind of that greed and personal interest. It alleges steps taken to conceal the bribery scheme. And then, of course, when you read the indictment, you just see that there's just a connection to Western Pennsylvania that just kind of jumps out of it. So I think they're going to have that, all four of those themes will be ready to go in that case. And I think that's, if you're a defense attorney looking at these things, and I kind of alluded to this a little bit before, how do I blunt some of those things? How do I blunt the personal interest? How do I blunt the abuse of power? And I think a lot of it is going to be things like, no, they got this wrong. These weren't concealing things. We had to do it because the Egyptian folks, they didn't have government email addresses or something, which actually does happen in some places. I'm making that up for this case, but that actually does happen in some countries. That wasn't concealment. That was actually just an artifact of the way they do business. Or, no, my guy was just a salaried guy, or he didn't get much money, or sure, he got a bonus, but it wasn't anywhere near what the government thinks would motivate somebody to risk their liberty for this. So you kind of think, marshal the counter evidence to try to blunt these things and try to take them on full steam. I don't know. You read the indictments, they're obviously DOJ picking the best evidence. They sound pretty strong, but these are the things that you still need to try to figure out. And obviously DOJ bears the burden of proving beyond a reasonable doubt. But I think in white collar cases like this, where these themes are so powerful, you need to be prepared to have a counter narrative about why they're wrong on all these things.
James, the other kind of area of inquiry that your article brought up is we've heard, I don't want to say since time immemorial, but at least since Sally Yates, we're going to prosecute individuals. And we're going to prosecute individuals. We heard that under every administration. And this administration has reiterated that. I recognize the cases that just happened or are coming up or started in the prior administration. But do you see this as a priority of this administration to really go after the individuals involved?
I think all prosecutors believe that. They want to, it's just common sense. Companies aren't real. They only work through their people. And so you need to try to get at individual behavior. And prosecutors believe the best way to get individual behavior is to provide them a powerful disincentive by risking their liberty. So I think it's definitely going to happen. The one issue is that trying an individual is extraordinarily resource intensive. And the reason is, companies, it's not easy to do an FCPA case against a company, but ordinarily they're not going to go to trial. They're going to resolve ahead of time. Individuals, because their liberty is on the line, they go to trial. And that means that you have to get all the witnesses ready. You need to get all the exhibits ready. You need to be prepared to brief all these issues. And it's a lot of logistical and just time-intensive work. And so I think that's one issue is, are they going to have the resources to do this? And that was one of the issues when I got to the DOJ FCPA unit. We had just brought the Siemens resolution, which was obviously gigantic, $1.5 billion total worldwide. But we did not, at the fraud section, have the resources really to try a lot of people. And I was like, that's actually why I was recruited from Miami, because I had tried a lot of cases in individuals. They wanted somebody who's going to be kind of court ready. And we built up those resources. So I think one issue is, with the resources DOJ has now, do they have enough to do individuals? Are they going to prioritize what they have to individuals? So it'll be an interesting thing to see how this shakes out in the smaller DOJ FCPA unit that we have now. But I think ultimately, prosecutors do believe this is the best way to deter behavior, which is to hold individuals accountable for their wrongdoing. And so it will most likely be a priority going forward.
James, unfortunately, we're near the end of our time for this episode, but if our listeners wanted to find out more about you or the firm, what might be the best place or places for them to go?
They can Google James Koukios, Koukios, only one U, and MoFo, which is always fun to put that into your Google. But we're at www.mofo.com. And of course, if they have a Law 360 subscription, they can search for my last name. And I just did it now, and the first thing that comes up is this article, if you've put my name in there.
James, I wanted to thank you again. I'm not going to let it go so long before I have you back. And go Blue.
Go Blue, Tom. Thanks.